the field of international criminal law, international human rights, and law of the seas. She's particularly had interest in maritime piracy and also private international law. She has published a lot of work in this area, and she will be providing us a lot of information specifically toward the international law and foreign relation law to the topic that we'll be discussing today. Professor Julian Koo is also a professor at law who is a distinguished professor in constitutional law from Hofstra University. He graduated from Yale University with a JD in 1998. His primary interest in relationship of international law to constitutional law in the United States. He's also conducted academic research on a wide range of topics, including international dispute resolution, international criminal law, and China's relationship with international law. He teaches courses as U.S. constitutional law at the university, U.S. foreign affairs law, transnational law, and international trade and business law. He also served as the faculty director of the international program overseeing Hofstra Law Study Abroad, and he has been focused, as I said, on international law topic and will be providing us a lot of that perspective on the topic we will be discussing today. And lastly, Professor Abraham Bill, who is also a professor of law at the University of San Diego University School of Law. He graduated with a JD from the University of Chicago and an SJD from Harvard University. He served as a clerk for Justice Moshe Kushin from the Supreme Court of Israel and for the High Court of Justice, the department within the Israeli State Attorney's Office. He was a visiting professor at the University of Connecticut Law School and Fordham University Law School. He's also a member faculty of the law at Bar-Ilan University and a professor, but also joined the USD faculty as a professor in 2009. He has a lot of extensive experience in constitutional law and international law and will be providing us his perspective on the topic that will be provided today from his personal experience and knowledge in these expertise that I mentioned. Professor Conservative.
Thank you so much. And again, this event is co-hosted by the George Mason Journal of International Law, George Mason Law School Journal of International Law, of which Ms. Al-Ghazali is the editor-in-chief, and the Center for the Middle East and International Law, of which I'm the director. We look forward now to hearing from our speakers, starting with Professor Stereo, then Professor Bell, and then Professor Koo.
Thank you so much. It's truly a pleasure to be here. Thank you for convening this symposium. I will be brief, as I know that you would like to allow us to have more of a discussion, and I would love to have our audience members have the opportunity to ask us questions again. Also, we're here to talk about a difficult, complex topic in international law. Let me begin by saying that when we talk about recognition, we're really talking about three distinct issues. We're potentially talking about recognition of states, we're talking about recognition of governments, and we're talking about recognition of borders. And so just allow me to briefly talk about the three, and then I'll come back to this issue of the recent recognitions of the Golan Heights and Western Sahara as belonging de jure, according to the United States, to Israel and Morocco, respectively. When we talk about recognition of states, in international law, there are basically two different opposing theories on that. One is the so-called declaratory view, and the other is the constitutive view. And these views are diametrically opposed. One says basically that recognition does not matter at all for the existence of a state, and then the other one says that recognition is one of the basic elements of statehood. And I would argue that when it comes to the existence of states and when it comes to territory, we all know that territory is one of the main elements of statehood. I would argue that territory and having a defined territory really matters at the time that a state is created and doesn't matter as much later on during a state's existence. So Israel has been a state for a while now. Whether it has Golan Heights or not, whether it has Golan Heights or whether it has sovereignty or not over Golan Heights doesn't affect Israeli statehood. And I would say make the same argument with respect to Morocco. So when it comes to recognition of states, although you might say that when another state recognizes a state, it thereby implicitly recognizes its borders, this really matters at the time of a state's creation, not so much later on during the state's existence. Second, when it comes to recognition of governments, there are also two opposed views here. One is the so-called effective control test, or what might what one might call the realist view, which really focuses on which government has the effective control over a certain territory. So, for example, the Taliban just recently took control in Afghanistan. Under this approach, all that matters is whether the Taliban have effective control of Afghanistan. It doesn't matter if they're a legitimate government. It doesn't really matter what type of a government they are. So long as they have effective control, they get to recognize a government. Diametrically opposed to that is a different view, which is really more legitimacy based. And under this view, only governments that come to power through constitutional means pursuant to the will of the people ought to be recognized. And I'll come back to this in just a second. In US recognition practice, we really have examples of both. And then last, recognition of borders. Here too, there are mixed views. There are plenty of examples in history and international law where territory acquired by occupation has been deemed illegal. And even with respect to the Golan Heights itself, there's a UN security resolution from 1981, which clearly states, and this is actually, the Golan Heights was occupied in 1967. Israel solidified its control over the Golan Heights in the 1973 Yom Kippur War, and then pursuant to domestic law, basically annexed the territory in 1981. And in 1981, there's a Security Council resolution 497, which declared the Israeli decision null and void and without international legal effect. And that resolution, is still in effect today. But let me speak a little bit about the different US practices, because we're interested in what the US does. Obviously, US acts alone do not constitute a binding customary norm of international law, but we all know that state practice is one of the main elements of custom. And we all know that what powerful states like the United States do does matter towards the creation of custom. So when it comes to recognition of governments, throughout the 1800s, the United States mostly adopted an effective control, realist view towards recognition, and basically recognized governments that had effective control over their territory, regardless of what type of regime they put in place. That really changed under President Woodrow Wilson, who was perhaps a moralist and had this idea of self-determination and the free will of the people as one of his main ideological tenets. And under his administration, the United States turned more towards a legitimacy-based approach to recognition. So for example, under the Wilson administration and a few subsequent administrations, the United States refused to recognize the Soviet Union as the legitimate government, the governments of Mexico, Costa Rica, Honduras, and Nicaragua. And under the same type of a legitimacy-based approach to the recognition of borders, there is precedent in history where the United States has refused to recognize forcible changes in borders. So for example, the United States refused to recognize when Japan occupied Manchuria. The United States said, no, this is not a legitimate border change. The United States also refused to recognize the USSR Soviet Union sovereignty over the Baltic states, which were occupied by the Soviet Union, refused to recognize, for example, the German occupation over specific territories in Western Europe during World War II. And more recently, as most of our participants would know, refused to recognize the Russian occupation of Crimea. Now, so those are examples of a legitimacy-based view that the United States had adopted towards both recognition of governments and recognition of borders. That being said, the United States has also adopted in the past and more recently a realist approach to recognition. So, for example, shortly after the Woodrow Wilson administration, the United States seemed to have turned towards a more realist approach when it comes to the recognition of governments. In the 1930s, the United States recognized the governments of Argentina, Bolivia, Peru, and Chile, just to name a few examples, despite perhaps some legitimacy-based questions that could have been asked about those regimes. More recently in Kyrgyzstan, when the president of Kyrgyzstan was basically ousted, the United States State Department basically said, sorry, too bad, we're not going to get involved. We're already in talks with the subsequent administration. And in 1999, the US recognized the Musharraf military coup in Pakistan that overthrew the democratically elected government in Pakistan. So those are just some recent examples of the United States realist approach, if you will, towards recognition. And then we come to the most recent examples, which are the 2019 recognition of Israeli sovereignty over the Golan Heights, and then the 2020 recognition of the Moroccan sovereignty over Western Sahara. Both of those acts of recognition were accomplished under the Trump administration, one in 2019, one in 2020. But what's really interesting, as Professor Kantorovich mentioned, is that the Biden administration has not reversed these acts of recognition. With respect to the Golan Heights, this act of recognition of Israeli sovereignty as, sovereignty de jure over Golan Heights was a major reversal in US policy. Up until that point, the United States has always officially subscribed to a two-state solution to the Israeli-Palestinian conflict, and basically this notion that all the territories occupied in 1967 were occupied territories, and there ought to be a peace process to resolve all of that. That pretty drastically changed in 2019 with the recognition of the Golan Heights as belonging officially de jure to Israel. And then with respect to the 2020 recognition of Western Sahara, which, as we were discussing just before the webinar started, many people didn't even really notice, because this is December of 2020, but many other things were happening at the White House. But that act is also significant because and I would say that it's somewhat tied to the U.S.-Israeli relations, because as a result of that, or as a condition of that, perhaps, Morocco actually normalized relations with Israel. So the Trump administration recognized Western Sahara as officially belonging to Morocco, and in exchange, Morocco agreed to normalize its relations with Israel. What's also significant in that act of recognition is that the Trump administration, in its official statement regarding the recognition, basically called for autonomy of Western Sahara within Morocco. So if we want to talk about self-determination, which would be another topic that we could have, countless webinars on, you might say that the Trump administration recognized Moroccan sovereignty over Western Sahara with this condition of Morocco respecting the internal self-determination of the people of Western Sahara. And so with all of that, I'm actually glad that we're having this webinar, because I'm really puzzled by all of this. I'm not sure that we can draw any type of normative rules based on this, because we see from the US practice that we have examples of a realist approach, we have examples of a legitimacy-based approach. Yes, these two latest acts of recognition are definitely more realist de facto based, but I'm not sure that we can, from those two acts, draw sort of normative conclusions as to what recognition means under international law. And I would also, the other worry with this is that if you say that now all that matters is a realist approach, whoever has de facto control over the territory basically gets to control that territory and has sovereignty over the territory, what do we do with respect to Crimea? Wouldn't that force the United States, if it wants to be consistent, wouldn't it force the United States to then officially recognize Russian sovereignty of Crimea? If Russia took over Georgia, other parts of Ukraine, if we're talking about a realist approach, we might have to say, well, then the United States now has to recognize Russia as the sovereign, de jure legitimate ruler of all of those territories. And so I would be worried about drawing any sort of general normative conclusions. And I would go back to essentially that these acts of recognition are political acts, are sui generis, are determined on a case-by-case basis, and definitely has to do with the US interests, with national security interests, with alliances that the United States has. And so I would stop here for now, and I look forward to your questions.
Thank you so much, Professor Stereo. That was really great. And Professor Koo, Professor Bell, you're up next.
All right, thank you. And I hope that the junior panelist that was with me earlier didn't disturb your concentration too much.
I just want to say this is also something legal. The antitrust breakup of Big Bell led to Baby Bells, and we see them.
Yeah, I'm not sure that those are the baby bells in question. Okay, if I may, I actually, I was going to speak about something that's quite different than what you've been discussing so far, which is not about the recognition of territorial sovereignty, but about the underlying substantive law of territorial sovereignty. That said, before I run off in a direction that's entirely different, I would like to just draw one contrast between my approach and that of Milena. I think it'll perhaps be helpful just to put on the table a different kind of approach to international law. And I'll just say in one word, my approach is frankly positivist. And so I tend not to draw this sharp distinction when it comes to customary law between what you call the legitimacy approaches and the realist approaches. To me, they ultimately have to converge. I've always thought, Louis Henkin had a very famous remark where he said that at the end of the day, most states, most of the time, observe the law. And I think that's right because of the way customary law is created. Right? It's a positive matter. Customary law in international law is created by the actions of states. And so what states do becomes the law. And so obviously, when one looks back at the end of the process, it turns out that most of them, most of the time, have been observing the law because they made it so. Now, I think that's apropos for our discussion here, because I actually think that what happened with the United States and its recognition of the de jure territorial sovereignty of Morocco and Israel, respectively, actually does have an effect on the underlying substantive customary law of acquiring territorial sovereignty. So there's a version of the rules of acquiring territorial sovereignty that you'll see in all the treatises and all the textbooks, and it tells us it's that when a state acquires territorial sovereignty by one of 5 what they identify as classic modes of acquisition. And they generally go back to Oppenheim, who in turn goes back, he says, to Grotius, and they in turn draw this from various concepts in Roman law having to do with property law. But it's a list that everyone repeats, sometimes in slightly different terminology. Accretion, cession, conquest, occupation, and prescription. That's the list that everybody uses, and then everybody starts arguing about it. So I wanted to focus actually on the claims that the parties here might make regarding prescription, and I think that actually that a prescription understanding of the claims of the parties is what underlies the U.S. Recognition of de jure sovereignty in each case. I will add that it is inherently both realist and legitimacy based. That is, as Oppenheim observed when he wrote about prescription 117 years ago, the claim of prescription, that is that states acquire sovereignty to lands that they have had long undisturbed peaceful possession of, even though that possession began with unlawful acts. Oppenheim says this is not something that sounds very nice to the lawyerly ears, but it is a fact of international affairs. And the family of nations therefore must accept it, right? And it's both realist and legitimacy based. That is, the legitimacy draws from the realism. Now, there, as I said, there's a great deal of dispute among scholars about how to understand prescription as a mode of acquiring a sovereign title. And there's dispute about whether, in fact, prescription works at all. Even those who cite prescription as a good mode of acquiring title, according to the classic list, then turn around and have trouble with it. You can see this most clearly, I think, in Brownlee's treatise, where he recites it and then proceeds to write about 6 or so pages about why, notwithstanding the fact that everybody agrees that there is such a thing, everybody should really agree that there is no such thing. And so he breaks down prescription into 2 different kinds of prescription: acquisitive prescription and extinctive prescription. And he says what you're talking about when you say that the states acquire sovereign title by virtue of long-term possession that begins with an unlawful act, that's acquisitive prescription, and nobody really believes in acquisitive prescription. He says acquisitive prescription must really mean that a state has held territory and the other state has, at some point along the line, acquiesced to the acquisition of sovereign title by that state. Now, this appears as far as I can tell, this appears in all the versions of Brownlee's treatise from the very beginning, all the way through the latest versions that were edited by James Crawford. But it's a somewhat unusual approach. There are others who take the claim of prescription at face value, that in fact, like the prescriptive acquisition of title in property law, prescription works by turning an unlawful possession into lawful title, and it does so by the passage of time and nothing else. Now, in historically, Grotius grabbed this doctrine from Roman law, what was called the Roman doctrine of Scapio, which is a doctrine that awarded title to a wrongful possessor who had acted in good faith. Now, the one thing that you can see running through all the writings, including those who don't accept prescription, is everyone agrees that this good faith condition did not carry over from Roman law into international law regarding the acquisition of title. That in fact, what we require in order for the mode of acquisition to work, for prescription to work as a way of acquiring title, is simply long-term possession. It has to be the kind of possession that is not related to property law, but the kind of possession that is related to sovereignty. That is, a state holding the territory as a sovereign, or the phrase that they will use is du titre de souverain, right? That is, holding it the way a sovereign would hold it. So that if you have long-term possession that is not based on the title of a sovereign, but is based on some other kind of administration, mandatory administration, or some other trust kind of administration, that everyone would agree that that doesn't work to transfer title by prescription. But otherwise, as long as the prescription is long enough, and again, for those scholars, I think at least the majority of treatises that I've seen, for those scholars who accept this sort of thing, what we're simply looking for is sovereignty lasting a long enough time. Now, there's another problem here, which is when you talk about acquiring prescriptive title in property law, it's generally linked intimately to statutes of limitation. That is, to rules that tell us how long you can hold a claim before it becomes stale. That is, at what point we extinguish the true title and transfer it to the possessor. Now, there are no such rules in in international law. There's no statute of limitations. There's some vague notions of latches, but it's not quite connected with prescription. And as a result, you see various kinds of assertions about the amount of time that would be required. If you look, for example, at the cases collected in the Oxford Encyclopedia of International Law, it runs through claims of 50 years, 60 years, 43 years, and it says, without citation, some authors deem 30 years sufficient. Right? I don't know where they drew the 30 years from. I wasn't right there. It has no citation. I'm not otherwise familiar with anyone who's claimed 30 years. But the disputes about prescription on paper have to do with items like the length of time. Both, by the way, in the case of Western Sahara and the Golan Heights, we're talking something on the order of 40-something years, right? That is, in the Golan Heights, it's been 40 years since Israel applied its municipal law to the Golan Heights, which would be the period when it started exercising sovereignty as the sovereign. Morocco has claimed to have sovereignty over the Western Sahara since before 1975, but it took until 1991 until it truly consolidated its actual possession. So we could start the clock running at 1975 or 1991. 30 to, what would that be? 46 years, right? All this within the range somewhere there of what we consider to be prescriptive title. The other dispute on paper that you see in the literature has to do with what constitutes uninterrupted peaceful possession. Particularly among the Brownlee crowd, the ones that are skeptical about the notion of prescriptive title, they insist that if there's an ongoing objection, that doesn't serve to establish prescriptive title, whereas the majority would say that the mere loud objection does not disturb the title. What we're interested in is exercising title as a sovereign over the period of time, and that is it. Now, I lay all this out because that's the dispute that exists on paper, but then I have to go back to where I started, which is I'm a positivist, and I take seriously the argument that customary international law is the practice of states as accompanied by opinio juris. And it's all very nice and good that the treatises have this dispute going on about how to interpret prescription. And occasionally they turn to various tribunal rulings, but that's not in fact what we're generally interested in establishing customary international law in general, or I would say in establishing rules of territorial sovereignty in particular. And so the real rules of customary law are the things that states do. And the fact that Brownlee and Crawford and Shaw and et cetera have a dispute about what ought to be the right interpretation of the Roman rule as translated by Grotius is all very nice and good. But the reality of it is that in fact, states do recognize long-term possession, even if it stemmed from an unlawful act, as sometimes leading to sovereign title. And that to me is the place to start rather than the place to end. So if one's trying to figure out where the rules of prescription have gone, I think that it should be much more salient in our minds that we're seeing recent examples of states accepting sovereign title based on long-term possession than the disputes over how to interpret terminology in a 17th century textbook in Latin. Thank you.
Great. Thank you so much, Professor. Now we're going to hear from Professor Kuhl, and then we will we'll take some questions. We'll have a bit of a discussion amongst ourselves and turn to the audience for further questions. Professor Kuhl.
Okay, thank you very much, Professor Controversious. Thanks also to Sally and the rest of the folks at the GMU International Law. This is Journal, and this has been a great opportunity for me to sort of think about something that I wasn't thinking about, which is very interesting, and to learn a lot from listening to Professor Bell and Professor Stereo remind me of things. But I'm going to shift and focus on a slightly different angle of this topic, which is something I've been more interested in myself, which I think domestic U.S. constitutional law framework and how that might shape the way in which these decisions are made by the United States. So I start as a point, which I think is an interesting, which I've always found kind of an interesting case, although I kind of haven't really paid much attention to it. It's a 2015 decision in Zivotofsky versus Kerry, which a U.S. Supreme Court, none of us were exactly surprised. I know Professor Kontorovich was actually filed a brief in that case, but maybe who did disagree. But I wasn't super surprised maybe about the results, which the case, which was about whether or not the U.S. State Department could essentially be forced by Congress to allow someone to list Jerusalem, Israel as their place of birth on their passport, that sort of. And the court held that because the president has an exclusive constitutional power over state recognition, that this congressional statute impermissibly interfered in that exclusive constitutional power. Now, what's interesting about this from a constitutional law perspective is that it's quite rare for the US Supreme Court to actually rule that Congress, when it passes a law, not that it exceeds Congress's own powers, but that it's invalid because it interferes with the president's exclusive powers. And although there are always theories about this, and there, of course, there are things the president claims are exclusive, it's quite rare for that to get to the Supreme Court and the Supreme Court to actually say, you're right, Mr. President or Madam President. Congress, by passing this law, interfered in something that the Constitution exclusively gave to you. And so I thought that case is kind of interesting at the time, although the result of the time was essentially to allow the State Department and the foreign affairs sort of establishment to maintain the U.S. position that Jerusalem was continued to be unsettled in terms of international status, and so therefore the U.S. take no position on whether or not it's part of Israel or not. And so I think that sort of essentially it's a huge victory for presidential powers. Now, what I think is interesting about this case is that, to me, looking back now and seeing how that power has been used since 2015, it's been interesting to see that we have the two examples, but also the Jerusalem example that we're talking about, the Jerusalem, Golan Heights, and Western Sahara, where because we had a very different kind of president, the president uses power arguably to go against the sort of the views of the U.S. foreign affairs establishment, and arguably, at least in a couple cases, against settled international law, certainly reversing existing U.S. policy, and in some cases against the views of a substantial members of Congress. And so, I think it sort of struck me that maybe there's something relationship between handing the president this rather unchecked, what I'm calling an unchecked presidential recognition power. And by the way, this does include the power to recognize territorial boundaries, like Professor Stereo usefully laid out. There's three different kinds of recognition: governments, states, and then territorial boundaries. And the Supreme Court essentially said it applies all three, that this is, and there's no, and so the key point here for US constitutional law is that Congress, even if it wanted to, could not interfere in a presidential determination to either recognize a state, the existence of a state or not, recognize a government or not, or recognize the boundaries of a state, of an existing state or not. And that it appears that there's no check within the US system on the ability, or very little check on the ability of the of Congress, on the ability of the president to make these determinations. And so is it surprising that the president was able to make the decisions to recognize Golan Heights, which, as it's worth emphasizing, as Professor Steer mentioned, reverses decades of US policy and flies in the face of the United Nations Security Council resolution that the United States actually, I think it might have even voted for, maybe, or at least did not oppose. And so these are kind of remarkable reversals of the Western Sahara decision, as we were discussing right before we started, reversed at least years of US policy. It drew a very angry op-ed from former Secretary of State James Baker. So it just, these are big, well, not big decisions, but they're big, they shift the decision, they're shifting US policy rather dramatically against what it was before. And so I guess my paper, my thought here is to think about, maybe there's something about the internal arrangement in the United States that might be driving the way in which the US makes decisions going forward, rather than thinking about external forces alone. And so what I think is that, and also to note, in contrast, and I'll just say this, that the United States, in theory, the president should follow international law. He might have a duty under the Constitution to take care of laws executed. Some people have argued that includes customary international law. And yet, and certainly Congress generally likes the president to follow international law. No, not always. And what's interesting here is that that it seems like there's more willingness to go against at least traditional understanding of international law. Maybe also because the president has essentially unchecked power. So I'm not gonna, and then what I'm thinking is interesting about this is that, let's think about the implications. So imagine you hand the president this power, which he sort of already had, but he never realized the court was gonna say, okay, you can do whatever you want. All right, so Congress can't stop you. The courts can't stop you, not that they ever could. But if you ever thought they would, they're not going to. And so now what are you gonna do with this power? Should you apply this power and say, well, we're going to follow it consistent with whatever international law requires? This is particularly relevant, a little less so with respect to recognizing the existence of the states, which itself, as Professor Stereo mentioned, is a complicated question. But certainly with respect to borders, as Professor Bell was discussing, there's a lot of law, international law, customary especially on the question of how to define a border. What is a legitimate or legal way to acquire territory? What is a legal claim to a territory? And you might imagine that the United States president would say, okay, well, whenever we make these decisions, we're going to follow international law. In fact, I was noticing in some of my research that the UK executive has such a policy. The United Kingdom Foreign Office, when it makes a decision about recognition, its policy is that it should always conform to international law. Now, the British are a little bit more fussy about international law than Americans are in this case. But that's at least the policy of the Foreign Ministry of the Foreign Office in the British cabinet. And in fact, they also try to limit it to fact-based determinations and try to make it less political, but also to conform to existing international law. And if you think about it that way and contrast it to the way the United States thinks about it, it's rather, the president does invoke international law to explain or justify decisions like the Western Sahara and the Golan Heights. But I think it's fair to say that despite what we're discussing here, the President Trump's administration was swimming uphill against the mainstream or established views of the international law rules with respect to what is the basis for the sovereignty over the Golan, or what is the who should be awarded sovereignty over the Western Sahara. So we have, I think, I argue at least, that within the US system, if there was this idea that Congress could check you or demand that you at least justify your decision, and possibly they could at least try to limit or reverse it, then the president would be less likely to make these bolder decisions that swim against international norms or run against other international institutions or other countries. But that by unchecking the president, we've smoothed the way to more of these decisions going forward. Now, let me just conclude by applying this to a very different context, an area I've been researching a lot, as Sally mentioned earlier. I'm doing a lot of research on East Asia the last 10 years. I really focused on East Asia. And one thing I didn't think much about until the last 10 years is there are a massive number of territorial disputes in East Asia for which the United States is completely neutral on. In other words, we don't agree. We're not sure whether Taiwan's part of China. Might be, might not be. We're not sure whether the Senkaku Islands are part of Japan. It might be or might not be. We have every island in South China Sea we have no position on. None, zero. Could belong to Vietnam, could belong to the Philippines. We just have no view, right? This is a good strategy for the United States and try to avoid problems. But what's interesting about this is that as the competition with China has increased the last few years, there's been more pressure on the United States to take a stand, right? Especially against China, and say, okay, well, no, actually, no, China, we no longer we take the view of X, Y, or whatever, and there's been a lot of pressure by allies in East Asia to push the United States to take positions. One example was Taiwan itself. The U.S. position on Taiwan is muddled and confusing, but essentially boils down to that we agree there's a China, and that's run in Beijing. We just don't take a position on whether Taiwan is part of China. It could be, it could not be. Now, I think what's interesting here is that there is increasing pressure in Congress. Every year there's a bill introduced, we should recognize Taiwan as an independent country. We should recognize Taiwan as not part of China. The US should shift gears and essentially recognize reality, et cetera, et cetera. Some of you might not realize the Chinese government is not happy about this position, but there's definitely building sentiment within the United States toward this. Now, what's interesting about this is that this is a pretty momentous decision. Under the Zivotofsky framework that I've described, this is purely a presidential decision. Congress can't make him do this, but Congress couldn't stop him either. President Biden tomorrow, I guess he wouldn't do this because he doesn't like to tweet as much, but they tweeted, we recognize Taiwan, right? Which he kind of blurted out something very close to it recently at some CNN town hall, that would effectively be irreversible within the US system. Now, I want to sort of think about, I think it's worth researching and thinking more about Taiwan or other areas where these decisions could make a huge difference, a massive difference with respect to how the U.S. foreign policy and whether and normally Congress does have a bigger role here, and I think the Zivotofsky case recounts a history where Congress was consulted. Congress did push the president. Congress did pass laws saying you should recognize this country. You should do this. You should do, where they're much more involved in supervising this recognition policy. And so I think it's worth thinking about what are the implications for this going forward. And my initial conclusions is that it's mixed, but it is the rule we're living with. We need to think harder about what constraints, if any, we want to impose on the executive branch as it exercises what is now recognized as unchecked presidential power. So thanks.
Oh, great. Okay, now the part I've been waiting for. I get to ask you guys questions, and I have a lot of questions for all the panelists. I'm going to run a few off just to sort of open the discussion. I'm going to go sort of, I think we'll now take turns talking about each of the papers in reverse order, while my questions for Professor Koo are freshest in my mind. And some of these are just going to be sort of passing factual comments, and some will be questions, and you can address them to the extent that you want. The question about the role of Congress is a really great and interesting one. As I read Zivotofsky, so I think there's a reading of Zivotofsky that is very defensible, that is very credible, and is nonetheless consistent with my amicus position, arguing for the opposite result. The court's ruling does not preclude a role for Congress. Right? It could, for example, the court says that Congress has control over international trade issues. So, for example, the president could recognize Western Sahara as part of Morocco, and Congress could refuse to ratify free trade agreements. Senate could refuse to ratify free trade agreements, or Congress could refuse to extend Moroccan tariff status to Western Sahara, which is exactly a dispute that's playing out between the European Council and the European Court of Justice. The diplomatic impact of that would be, almost the same as if the president were to unrecognize it. Like Morocco would, I think, feel it has not gotten the benefit of its bargain. And as a matter of fact, one of the first things President Trump did to try to cement the recognition of Western Sahara was to move to open a U.S. consulate in Laayoune. And there are currently moves in Congress, I don't know the status, to bar funding to such a consulate as a kind of practical act of recognition. And certainly there's, treaty, the tariff issue is very important. But interestingly, so Congress was not significantly consulted about Western Sahara, but in the cases of the Golan and Jerusalem in particular, there was significant consultation. Right? Zivotofsky arose from a law passed by Congress encouraging the president to do what the president ultimately did. So that's the strongest form of consultation. There were hearings in Congress, both about the recognition of Jerusalem and the Golan before they were done. I testified at both. And I think it's fair to say that there were some voices of sharp disagreement. The overwhelming sense of Congress was not highly critical, and those who were concerned about these recognitions focused mostly on pragmatic arguments like it's going to lead to violence, there's going to be conflict with surrounding Arab states, and other prudential matters which turned out not to materialize. And it's not clear that the fact that the U.S. ability to engage in these recognitions, one way to think about is it really a result of U.S. Constitutional structure would be to compare it to other countries. And much to my surprise, I have learned in recent months, in the past few years, a large number of countries, or let's say a few dozen, have begun to recognize in various forms Western Sahara as part of Morocco. And these are countries such as Kuwait and Jordan in the Arab world, and Luxembourg, and potentially France, depending on how you interpret some comments in Europe. In other words, and sub-Saharan African countries. In other words, a diverse mix of countries with different motives, but also fundamentally different constitutional structures. So it suggests that maybe they weren't, that maybe it's not particular to the US. Finally, on the very important question of international law and binding the president to international law, of course, as we know, the position of the US formally is that the president is not bound by international law as a constitutional matter. But the underlying reason, seems to be that international law is, as Gouverneur Morris put it at the Constitutional Convention, too vague and deficient to be a rule. So as Professor Bell, described, there's this dispute about what does international law say, and exactly in cases where maybe you need to make a judgment call, and where it would requires updating judgments to sort of ongoing facts. So, for example, things look different after 20 years of control than after 50 or 70 years of control. Things look different if it's part of a comprehensive diplomatic settlement. Right? Cases like Dames and Moore versus Reagan sort of emphasize the ability of the president to throw things in to settlements. And of course, recognition of boundaries are the kind of things that often come with comprehensive settlements. Britain only recognized America's northern border with Canada as part of the Webster-Ashburton Treaty of 1842. So maybe the president is in a perfect place rather than Congress, which might be slow to adapt to shifting realities. And then what would the consultation look like? I guess that's a question. So Jerusalem was like the highest and best level of consultation. They passed a law saying do it, right? Golan was a lesser consultation. There were hearings, right? There was not like a majority of congressmen or senators opposed. Western Sahara was a surprise to everyone, and maybe Congress can still do something about it. Okay, those are some thoughts, and then after that we'll take questions from the panelists.
Oh, okay. So I think that was for me, right? Or okay, all right. So let me just quickly. I want to leave time for other folks. Yeah. So this is really good. I think I should refine my analysis. Say they're kind of offensive versus defensive congressional supervision of recognition. So I think you're right. Jerusalem is where Congress is pushing. I'm not sure whether that's offensive. I guess they've literally been slamming the president for years and trying to make him do something that he didn't want to do, right? And Zivotofsky actually endorsed his ability to say, to give Congress the Heisman and say, forget it, Congress, we're keep trying, we're not going to do it. So I think that sort of is, I think, where maybe the most salient is, where the president doesn't want to do something and Congress is trying to push him to do something, right? So, I noticed a bill introduced recently that we should recognize Tibet as an independent country. And it's very easy. This really gives the president the ability to say no, and to say, we're just not interested in going down this road. So I think that's the most. So that's not, now the question is what happens in the other circumstance where the president does something, which I think Western Sahara is maybe, you're right, the better example, where it's not so much they're against it, but they're sort of against it, or they're at least didn't realize it was coming, and they're kind of mixed, and they weren't really consulted. And I think that the Congress might even oppose it. Or the more dramatic example that Professor Stereo mentioned, which was suppose President Biden's like, to make a deal with Putin and bring Russia back into the fold, we're going to recognize Crimea. Like, we're done here, right? I can see Congress that not going over well in Congress. And I can see that the conflict, and I think Congress has levers, but I think the first mover advantage is still quite dramatic. I think a president with sort of authority in Congress can, I think, block a lot of moves And once they make the decision, it's certainly very hard to reverse, and Congress has less leverage over that. So I think it's a little bit like the war question: should the president use force without Congress? The president appears to be able to use it, and we're getting to that moment where the president seems to be able to do whatever he wants, almost militarily. But politically, the president should consult with Congress, because eventually that's going to come back to bite him. I just think it's interesting that this dynamic is a little less dramatic here in recognition, but I do think that we see this. This is an important sort of dynamic that we need to sort of think more carefully about. One thing I've been interested in is Congress itself is becoming more interested in foreign policy in the sense that they themselves are subject to lobbying from foreign interest groups and local domestic interest groups that try to shape and push US policy. So here I think it is interesting that we're cutting Congress out a little bit more, and I think that will change the dynamic. But I agree with you that it's not a one-way thing where it's always going to be president's going to do more. I think it's a more complex relationship than that, and it's worth. And each example might be a little different. I myself argue that with respect to Taiwan, we're more likely to see Taiwan being like Congress saying, pushing the president to recognize Taiwan as an independent country, and the president saying, using Zivotofsky as a shield to say, forget it, or I'm not doing it. And that may be the more powerful use of this power. So, thanks.
Okay, Ms. Al-Ghazali has a question also for while we're still.
Yeah. Thank you, Professor Kantorovich. So I have a question specific to Professor Koo, but Professor Styria and Professor Bell, please feel free to chime in if you have anything to add. But on this whole idea about Congress's effort and Congress's input in foreign relations, I feel it's a little bit, it's really interesting that based on what Professor Kantorovich had mentioned, and you also mentioned in terms of what efforts and what powers the Congress have in these areas, and it's not very limited, it is a little bit limited. And when we look into the courts, specifically in the ruling of Zivotofsky 1, where courts usually try to kind of argue the political question, so we see a little bit of not a lot of like checks and balances on the decisions of the president making these kind of policy recognition. But how do you respond to the argument that the president is the sole organ of communication with other countries and he should be the one to be able to make those decisions because no one is in a better position to communicate these foreign relations with other nations? I think this ruling was mentioned in Curtis Wright and has been relied on by many arguments in Supreme Court cases, arguing that the Congress should not actually have an input in these kind of recognition. So what do you respond to that?
Okay. So the Curtis Wright. Well, I mean, Curtis Wright has been sort of puzzled over many years. In Zivotofsky itself, it was cited, although the dissent point out that Curtis Wright itself was only citing the speech by John Marshall when he was not a Supreme Court. I mean, the authority for Curtis Wright is as a sole organ theory is murky at best. It's not really grounded specifically in the text of the Constitution. So it's a powerful idea, and I think it goes down to boil down to what I think the argument of Zivotofsky is. Like, you can't have Congress do this. You should not have Congress involved in this. But I think, and I'm generally a presidentialist on many things, but I think there's some reason to think that as these things get more complicated, it's too easy to say this is just a presidential decision. Congress is going to want to be involved anyways, and Congress is pushing in each direction. And so I think that dynamic and that relationship, I've been struck by just how often congressmen throw things in the National Defense Authorization Act, or they have hearings and they're lobbying. They're really, not all of them, but some of them are interested in trying to push along the US government on this. So you're right, the sole organ is out there, but I don't think, and I think what's interesting about Zivotofsky is that it kind of, for the first time, because Curtis Wright, in fact, did not actually need that holding to reach the result, but Zivotofsky, for the first time, really did say, because of the sole organ, we're now going to shut down Congress on this particular issue, right? That their power goes too far. So that does open the door, I think. But I'm not sure Curtis Wright and Zivotofsky necessarily is correct as a matter of law, but certainly I think you're right that Zivotofsky reflects the Curtis Wright view of things, and I think that's where we're heading. And so my project is to try to understand how that's going to affect the way we go forward on these sorts of decisions.
Okay, great. I'm gonna bring some more questions to the other panelists and myself, and then we'll turn to the audience questions. If you have audience members, if you have questions, please put them in the chat. We'll get to them shortly. Professor Bell, one question for you. It responds to, we hear a lot in discussions of recognition. There's a lot of what I call, looking under the lamppost for the keys. That is to say, everybody remembers the few famous non-recognitions. So to take, for example, the Baltic nations not being recognized by the United States, though of course being recognized by much of the rest of the world as Soviet, but not being recognized by the United States and the UK as being Soviet. On the other hand, you have Armenia, Azerbaijan, and most of the other Soviet socialist republics, which were absorbed into the Soviet Union, having previously separate countries in the early 20s in the Russian Revolutionary Wars, where the United States finally did get around to recognizing about a decade later the Soviet Union. It recognized them. It recognized it with all of those annexed provinces, annexed republics intact. So I think Crimea is not such a stretch, right? The idea is Crimea is impossible. That's exactly what America did when it recognized the Soviet Union in the first place, is recognize Russo-Soviet other ethnic republics. But then, so we actually kind of see two models. The biggest examples I can think of recognition of territory taken by conquest in recent times, I think there have been prominent examples, such as the American recognition of the absorption of the Republic of Vietnam into communist Vietnam, when America finally recognized Vietnam in 1901 under the Clinton administration. It was with all of the borders of the former Republic of Vietnam, an entire country. Goa, of course, the Indian annexation of Portuguese Goa and surrounding enclaves in the 60s. Well, those examples, of course, were different in that they recognized they sort of immediately recognized annexation, or very promptly immediate. So maybe what we're seeing here is what we would call some kind of mitigating or gentler doctrine of prescription, where the time is really being stretched, right? And it's being stretched to the point where it would be maybe potentially hard to imagine incentive effects. Like, it's hard to imagine a strong man or a leader of a country thinking, I'm going to do this now, and in 45 years I'll get recognized, because that's beyond most planning horizons. So maybe in a sense this is a reversal from a previous policy of occasionally recognizing immediate annexations to putting some kind of clock on it. What do you think about that kind of or taking a longer view of prescription?
So there is a reason that these modes of acquisition are thought of as distinct, right? So the mode of acquisition of subjugation or conquest is based on the idea of annexing subsequent to conquering, and everyone agrees that it used to be good as a method. And if you consult the textbooks, everybody agrees that it's mostly dead or completely dead. And as you point out, that actually doesn't reflect what happens in reality in world affairs. In world affairs, conquest is sometimes seen as an effective means of acquiring sovereignty, and sometimes not. Now, prescription is different. It looks at something. It looks at a different phenomenon, which is possession over time. And it doesn't really make a difference whether it began with conquest or began with something else. And it's actually used fairly frequently in that sense by tribunals. They just generally don't call it that. So tribunals that look at what they call effectivité, right? The effectiveness of the possession of a state, without going too far into how it began or whether it began according to law or not. That's a case of prescription, and I wouldn't look at it as an alternative to conquest arguments. It's its own entirely different world. But I think the same thing is true of prescription as what you just pointed out about conquest, which is, there's a version that you see in the treatises, and then there's the reality of the world. The reality of the world is somewhat different than what you see in the treatises. And I think that the reality is more complex and more ambiguous. If I can, I'd like to relate this just to one last thing that, something that Julian said and that you were addressing. There's when Julian was talking about this, about the way different countries approach questions of recognition, you were talking about, say, a British approach, where it stems from first looking at what international law has to say, and the United States doesn't really approach things that way. I would say that Eugene said, well, that this goes back a long time. The president is not really bound by international, because the international law, it doesn't have sufficient crispness to it or clarity to it. But I would say it's beyond that. The nature of international law is customary international law is that it's always in flux. It's changing all the time as states are doing things, and it's only as we look backwards we can see into what it has developed. And what that means is that when you look at a presidential decision, for example, to recognize or not recognize de jure, and that is by its nature, when you say de jure, by its nature, you're talking about an international legal decision, right? When the president does something like that, it's not purely a decision about how to interpret the application of law. It is in part a decision about how to create law. That is, the president is creating a piece of future custom for the rest of the world. And when you're talking about the president of the United States, it's a significant piece of custom, right? Maybe it's less important what the Prime Minister of Israel does, or the King of Morocco. But when the president of the United States does it, it's there's a significant bit of lawmaking there, not simply law accepting. And so just as I have trouble making this clean line between realist and legitimacy approaches, I think that it's not right to look at this as decisions that are made in accordance with international law or not in accordance with international law. In a large part, these are decisions that are made with an eye towards transforming or moving the law into a new space.
Okay, great. And I'm going to wrap up with a question for Professor Stereo. Professor Stereo, and I think this is reflected in a question from one of our audience members, that there seems to be a disconnect between theory and practice. And Professor Stereo, you say that there's the schizophrenic or two aspects. There have been two sides to American recognition policy. One may be idealistic or normative, and then paralleled simultaneously with a strong realist strain. So I would suggest maybe as a question that maybe when you have a parallel, intertwined and back and forth schizophrenic idealist and realist policy, that the conclusion, just when you have a multiply, a minus, a positive and a negative, right? You have one positive and one negative, but when you multiply them, you always have a negative. So when you have a realist and idealist, what you really have is realist, but, and with the even meta-realist point that it's a recognition as a political matter conducted in a realist way. And part of realism is you can choose when to be ideal. Clearly, I think everyone would agree there's no requirement of recognition of any particular borders, government, or state, right? It's a discretionary action. It's not obligatory in any country. You don't have to have foreign relations with any particular country. So if recognition is a political act, part of the political act is you can choose how you're going to play it. You can play it realist and you can play it idealist, but that's even a more meta-realist point, right? Realist plus or times idealist equals realist. Okay, what say you?
Yes, I do. I do actually agree with that. And here's what I would say: based on everything that we see from these various acts of recognition or non-recognition by the U.S. over the last, let's say, 100 years, I would argue that the U.S. basically recognizes different states, governments, border changes when it's in the U.S. best interest to do so based on its own foreign policy, based on its own national security. So these are purely political acts. They are realist, Eugene. I would absolutely agree with you on that one. Where I would perhaps push back a little bit is, if we try to construct from these acts of recognition, which let's agree, you and I, it's a realist view of recognition. If you then try to say, okay, well, what does international law say about this? Or, is there some customary norm evolving based on this? I would push back against it and said, absolutely not, because these are political acts based on the US best interest, the US foreign policy. And I think it would be absolutely wrong to then from there say, okay, well, customary law is now evolving. I would absolutely push back on that because, for example, when it comes to, for example, the Golan Heights, yes, the United States has now recognized it and the Biden administration has basically upheld that. There's actually a tweet by the State Department from like May of 2021, where the State Department says in a tweet, this is the Biden administration State Department, the Golan Heights policy remains the same. There's no change. But we see the rest of the world not agreeing with this, right? We see all other countries in the world not recognizing Israeli sovereignty over Golan Heights, and we see a UN Security Council resolution, back in 1981. So I would say realist view, recognition is political. The United States has this realist view, and I think it is likely that will remain to be the case, right, in the near future. And I would say that in cases, I think Professor Kuh alluded to this, in cases where the United States is sort of like not sure what to do, or it's I would say in cases where it's in the best interest of the United States to remain sort of neutral, we see this attitude of kind of like wait and see. So for Taiwan, we don't really know. And we see in the recent examples, the Taliban taking over Afghanistan, the military coup in Sudan, we see basically the US State Department saying like, we're not officially going to recognize these regimes, but it kind of remains to be seen as to how and whether the United States will actually engage with these regimes. Because there's a lot to be said about in cases where there's no formal recognition, the United States can, of course, continue to engage with these regimes and can have diplomatic relations, and can do things, can interact with these leaders, even without the formal acts of recognition. And so I would say, yes, 100% actually a realist view, perhaps couched in terms of legitimacy in some instances. But if you try to draw any kind of objective rules or sort of have consistency about this, it is very difficult to reconcile different cases, so it's really difficult to reconcile why is it that the United States, with respect to the Baltic states, which you so aptly mentioned, why is it that the United States withheld recognition for 50, 60 years? If time plays a role, shouldn't those have been recognized? We see in the recent, for example, you mentioned like Azerbaijan and Armenia in the recent conflict over Nagorno-Karabakh, Armenia had actually occupied significant portions of Nagorno-Karabakh. Azerbaijan has now taken some of it back, but for about 20 years, it was Armenia, right? So why is it, why shouldn't we then say, well, okay, this is now, rightly Armenian? And so this is where I think it's very hard to draw rules like positive law, normative rules based on this. And I would argue recognition remains an act of politics that the United States exercises pursuant to its own interests.
Okay, excellent, great. And I think that leads us nicely into a question from an audience member, from Andre de Who, which I hope I'm pronouncing that right. Or, in any case, my apologies, who or how. But let me summarize the question, that you can look at this either as contributing to state practice, as would any other country's recognition, like I've meant of any other situation, from either recognizing Western Sahara as part of Morocco, as some countries have done, or recognizing a state of Palestine, or if it's in conflict with some norms of international law, maybe it's a violation of international law and then would trigger another norm, namely a norm of non-recognition. I think Mr. Dahu is suggesting that non-recognition of US recognition. So the question is, would you be inclined to use these examples from the perspective of contributing to a rule or inconsistent with an existing rule? And let me take the first crack at this. I would give a meta answer to this, that I think one thing this clearly shows is there's not some meta rule of non-recognition of other countries' discretionary recognitions, because what we haven't seen is any any member of the international community taking a position or announcing their non-recognition of US recognition, or taking some kind of countermeasures. As far as I know, European diplomats have attended events at the United States Embassy in Jerusalem. They do not boycott the US Embassy in Jerusalem, or at least many of them don't. So whatever the, whether it's a violation of the rule or contributing to a rule, and again, in customary law, presumably all establishments of a new rule are in violation of some previous rule, but certainly it doesn't seem from the practice of other states that there has been any recourse to a meta rule of non-recognition of recognition. If I understood the question correctly, I'll let the panelists take a crack. Anyone want to address that?
I'll jump in real quick. I think the issue here is how you view recognition. Do you view recognition as a political act, or do you view recognition as an act governed by law? And I think that if you take a view that recognition is a political act, which I think many people do, then it's hard to say that there's a duty to do X, Y, and Z. Because if it's political, then it's discretionary, right? So it's really only if you view recognition as somehow governed by a set of international legal rules that you can say, there's a duty, for example, not to recognize in these cases, right? So, I'm more in the camp of recognition is a political act. We can criticize it. We can be against it. States can certainly say, for example, the United States should have never recognized Golan Heights or Western Sahara as belonging to Israel or Morocco. We can criticize it. Other states can certainly, at a political, diplomatic level, react to it. But I think it's hard to say that there is some, steady international law rule that says there's a duty to do X, Y, and Z. In the Golan Heights case, perhaps one complicating factor is the Security Council resolution. So if you want to, talk about, rules that we have, but the Security Council resolution talks about the annexation. It doesn't really talk about recognition, right? So, I'm more in the camp of recognition as a political act. I'm not sure that there is an international law, norm that says states must do X, Y, and Z.
Anyone else want to address this?
If I could, I actually would like to call a different example. Think for a moment about Northern Cyprus and the rest of Cyprus. Right? I mean, there's pretty much a consensus, as much as there can be on such things, that there is no such thing as the Northern Turkish Republic of Cyprus. It's a country that is recognized by Turkey and by Turkey alone, and the rest of the world sees it as an occupation by Turkey. That said, when it came time to start negotiating, the proposal on the table was not for a Turkish withdrawal from Northern Cyprus, but was in fact about cementing and turning that rule into some de jure recognition. And I think that we all understand that if the deal had actually been carried out, then we would all turn around and retrospectively say, oh, well, obviously there is a Turkish Republic of Northern Cyprus. All these things, they're the rule until they're not the rule. And Eugene, as you said, the way that customary law comes to change is by people violating some norm that was thought to exist beforehand, or reinterpreting it, or thinning it, or expanding it. And so you can't look at it in this fashion of, right? Is there a duty to not recognize? I don't see that the norm of non-recognition is a norm. So certainly I have to agree with Professor Stereo that there's no norm to not recognize non-recognition. That is, it is an essentially a political act. I disagree here because it is a legal act, right? That is what all creation of customary international law is. It is of customary international law is the fixing of international norms out of political expediency.
Okay, great. We have time for just a couple more questions. Let me read a question from EM on Earls. To what extent does U.S. recognition influence the keeping of boundaries that may no longer make sense? Examples that U.S. pressure may contribute to the boundaries of Bosnia and Herzegovina, Afghanistan, Democratic Republic of Congo, together in spite of total internal fragmentation. And maybe, I think the suggestion is maybe US recognition policy is too reserved against, I suppose, secessionist claims.
Yeah, I'll just say on this one, I think there's a lot going on here. And it brings up the broader question of what's the strategy for using this political power, right? If we're going to call it a political act, what's the policy goal here? And I think the U.S. policy generally is in favor of stability, right? And that's why the U.S. has generally recognized existing borders. And frankly, that's the policy reason behind all these rules, right? We're against conquest because it's destabilizing, right? We don't want to encourage more of it, right? And that's why we don't recognize it, because we did recognize it, then would contribute to this, these sorts of conquests. And so I think that's the policy justification for the rule, so to speak. And that's why, and I think the broader picture here, I think I was also wanted to mention was that the U.S. is influenced by other countries, and right now, for instance, just to put it in the modern frame, one of the big policy goals is competition with China, right? So you hear that all the time. And then part of that competition is we want a rules-based international order. This is US policy, unlike those Chinese government people who are challenging the rules-based international order. Now the Chinese are like, that's not fair, we're not doing it. But the point is that this is, if that's the frame, then whether it truly is a political act, the US decisions have to be framed within international law. And so when they depart from it, or depart from existing rules, then I think it is in tension with their so-called declared policy, right? Which is we're in favor of rules, unlike those other people. So that's I don't know if it's meta realist, but it's a policy-based explanation for at least the rhetorical adherence to international law, even in these political acts.
And if I could just jump in on this as well, the question about sort of the U.S. influence regarding pressure to keep, certain borders, I would actually add to your list of examples Kosovo, and I would say that there's definitely tremendous U.S. pressure to keep the borders of Kosovo as they are, although the northern part of Kosovo is basically 100% Serbian occupied, and you might say you could draw this border and say separate out the northern part of Kosovo, give it to Serbia, and it sort of solves the problem. I'm being too simplistic, right? But there are certainly arguments, to that extent, and yet, because of very strong U.S. policy on, I would say, against Serbia, in favor of Kosovo, I would say that we definitely see example of borders being influenced because of U.S. policy. And I would add just a couple of other things. I would say that although to me, the way I look at this, I think recognition is a political act and international law isn't clear. We do have clear international law rules on the use of force. International law clearly prohibits states to use force against each other. We have clear international law rules on occupation. We have international law rules and principles on self-determination. So there are international law rules on many of these issues. However, it is not clear to me that recognition is directly linked to those rules. So although I would agree with Professor Koo that obviously when the United States does or does not do something, it's always careful to frame it in terms of the United States is acting consistently with, this international law framework. But at the same time, I would say that it's not clear to me that recognition is directly governed by international law rules, which is why we see the United States State Department making policy-based arguments all the time, and saying, for example, well, this is just sui generis, and even, for example, the Golan case, Secretary of State Blinken said, oh, well, for now, this is a huge issue of national security for Israel. If things change in Syria someday, we might revisit this, right? I mean, I don't think it's likely that they will, but, he framed it in terms of this is a serious national security issue for Israel, which I think was not a coincidence. And then, Professor Bell mentioned Northern Cyprus and sort of consensus. I think it's sort of, it's tricky to talk about this because, for example, with respect to Golan, you might say, well, there's consensus among the world community, except for the United States, right? That this ought not to be recognized as Israeli sovereign territory, right? So, that's why I pause, that's why I think that these acts of recognition are so inherently political. And, the United States, as the most powerful country in the world, is basically allowed to do as it wishes. And then the last thing that I would mention that we haven't talked about, but I would argue that in this realm of international affairs, the Security Council plays a huge role, and obviously the veto wielding member states of the Security Council. So when it comes to, for example, Russia taking Crimea, Israel doing anything, we see the USSR, now Russia, and the US in a position to veto any Security Council resolution that would sort of strongly condemn it, authorize the use of force, authorize sanctions. And so I think the big elephant in the room here is power, which is linked to the ability of these super powerful states to essentially engage in recognition practices as they see fit.
Let me make one comment inspired by this question. It'll address another outstanding question, and then we'll wrap up. What's interesting for me, so all the examples given of United States being risk averse or rule bound in recognition were examples that would involve the disintegration or the cession of existing states, and in particular the creation of new states. So I think there's a hierarchy in recognition. And one might distinguish, I think, there might be reason to distinguish between the recognition of states and the recognitions of borders of existing states. Creation of new states is a fairly big deal and typically comes at the expense of an existing state, and could thus be seen as particularly destabilizing. In particular, in a realist view of the international system, you might imagine that existing states, like the United States, like China, would have a uniformly critical view of the formation of new states out of the territory of old ones, because it can't be good for them. On the other hand, border disputes between existing states is bad for one state, good for one state, good for another. Presumably, it's a wash. It's not something that existing states might have a systematic interest in, which they might imagine a more flexible or permissive move. And I think it's not a coincidence that all of the U.S. recent recognitions have involved the borders of existing states. I think it's no coincidence that countries like Luxembourg, which I think would never think to recognize, say, Kurdistan or Taiwan, have taken a different position with regards to Western Sahara. There may be more give on that issue. In any case, thank you all for joining us. Thank you very much to the Journal of International Law, Ms. El-Ghazali, for having us, to our great panelists, Professors Kuhl, Bell, and Stereo. Hopefully in about a week, video of this will be available on the website of the Center for Middle East and International Law, and various papers will be forthcoming. Thank you all.
Thank you, everyone.
Thank you to the attendees.
Thank you.
Thank you. Thanks for joining. Thanks. All right, guys.